Okay, let's unpack this. We're diving deep today into a legal journey, an odyssey, really, that begins in well, the profound shadows of a childhood shattered by trauma.
Yeah, and years later, that really painful past became the absolute central battleground in a whole new legal fight.
A fight that climbed, all the way from Queensland up to the highest court in Australia.
It's a really powerful and complex case. It just shows how deeply past events can echo how they influence justice now.
Absolutely. The case is known as Cook. That's a pseudonym, of course, v. the king. And it digs into some deeply sensitive issues.
Yeah, focusing right in on that critical question, how or maybe even if evidence about those earlier traumatic events could be used in a trial about later allegations.
So our mission in this deep dive, based on this stack of sources you've shared, judgments, articles, notes, is to follow this case's path, the procedure.
Understand who the key players were at each stage, the judges, the lawyers.
And really pinpoint what was actually at stake in this, pretty significant legal fight.
And it definitely takes us into some, let's say, technical legal areas, especially the rules around evidence, specifically evidence of a complainant's past sexual experience in these kinds of sensitive cases.
And that whole balancing act judges have to perform, right?
Right.
Protecting vulnerable people versus ensuring a fair trial.
Exactly. It's a constant tension.
So let's start right at the beginning with those shadows of the past, as the sources describe it.
Okay. The initial trauma involved the complainant experiencing sexual assaults by someone the courts just called the Queensland offender.
And this was happening in Queensland between, January 2008 and June 2009?
Yeah, when the complainant was incredibly young, just 6 or 7 years old.
That early period is just so foundational to everything that followed.
It really is. And the material shows she actually disclosed this, told her stepmother in June 2009.
But tragically, at first, her stepmother and father, they didn't believe her.
Yeah, imagine how isolating that must have been.
Such a difficult start. But then things did shift. By July 2009, arrangements were made for her to move.
Right. Move interstate to New South Wales to live with her father's sister, her aunt, and the appellant in this case, the man known as Cook.
So that became her new home environment.
And pretty quickly, too. By September 2009, just a couple of months later, the NSW aunt actually became her legal guardian.
So this wasn't just like a temporary thing. It was a formal change in care.
Stemming directly from what happened or what was alleged to have happened back in Queensland.
Okay, and here's where the timeline gets really crucial, where things start to overlap in a significant way.
Yeah, because around late 2009, according to the sources, the complainant disclosed the Queensland offending to Cook, the appellant.
Think about that timing. This disclosure happens more than a year before the first alleged offense by Cook himself is even said to have occurred.
And the sources give us these little glimpses, these details of the disclosures. Talking in a car at Bunnings, I think?
A hardware store, yeah.
Yeah.
Describing cable ties, even asking Cook, that heartbreaking question, would he do what the uncle did?
So powerful. And this really introduces our initial set of key people, our dramatis personae for this early phase.
We've got the complainant, the appellant Cook, the Queensland offender, the NSW aunt, and the complainant's father and stepmother.
Their lives, their actions, their interactions in this period really set the whole stage for the legal drama that unfolds years later.
And now, while all this is happening, the move, the new home, the disclosures, there's another track running in parallel.
Right. Back in Queensland, legal proceedings against the Queensland offender were actually underway.
This context is so important. The sources map it out pretty clearly.
Okay, so April 2011, there's a committal hearing for the Queensland offender. And Cook, the appellant in our main case, he actually gives evidence at this hearing.
Helping build that case against the Queensland guy, who was then committed for trial.
Then, April 2012, the complainant gives her evidence for that Queensland trial. It's pre-recorded, as often happens in these cases.
And here's that striking overlap again. The material points out that by this stage, April 2012, the first 11 counts alleged against Cook himself were said to have already happened in NSW.
So she's allegedly experiencing new trauma while simultaneously participating in the legal process for the old trauma. It's a lot to comprehend.
And Cook wasn't just a background figure in the Queensland case either.
No, not at all. In late 2012, he actually gave evidence in the Queensland trial as a complaint witness, supporting the complainant's account.
That trial ends in November 2012, with the Queensland offender being convicted. Multiple counts of rape and indecent treatment.
But as also happens, that wasn't the final word in Queensland. There was an appeal.
Right. July 2013, the Queensland Court of Appeal allows the appeal, throws out the convictions, and orders a retrial.
which meant the complainant had to go through giving pre-recorded evidence all over again for this potential second trial.
But that retrial never actually happened in the end.
No. In October 2013, the Queensland offender pleaded guilty, but to fewer, less serious charges, 4 counts of indecent treatment.
So the key takeaway here is that this whole Queensland legal process, police, courts, lawyers, Cook himself being involved as a witness, was actively churning away.
Exactly. All through the period the complainant was living with Cook and, according to the later NSW allegations, being assaulted by him.
Which brings us directly then to those NSW allegations.
Okay.
The ones against Cook.
Occurring between January 2011 and 2014. Again, notice that time frame, it perfectly overlaps the Queensland proceedings we just discussed.
And these NSW allegations, they eventually lead to a trial in the District Court of New South Wales.
That trial started on July 31st, 2019, and the judge presiding was Judge Colefax, SC-DCJ.
And right from the get-go in that courtroom, the massive legal fight wasn't just about whether the NSW offenses happened, it was about the past.
Absolutely. The central battle was, could the jury hear about the Queensland offenses? Could they hear about the disclosures, the court cases, Cook's own involvement back then?
And this whole fight really zeroed in on one specific bit of law, Section 293 of the Criminal Procedure Act 1986 in the NSW.
Think of Section 293 as like a specific shield. It's designed generally to restrict evidence about a complainant's sexual history, or, the term used is, sexual experience.
The aim being to protect vulnerable witnesses, stop unfair assumptions being made based on their past.
Right. But Cook's defense team saw that Queensland history as absolutely vital for his case.
Their argument essentially was, we need to tell the jury about this. About the earlier assaults, the fact she told Cook about them, the fact he helped prosecute the offender.
Because, they argued, it helps show maybe her memory of the later NSW events is mistaken or confused. Or maybe, just maybe, it makes it seem inherently improbable that Cook would do these things to a child he was supposedly protecting and helping get justice for.
A sort of context is everything argument. But they had to get past Section 293.
Exactly. So they argue that even though SU 93 generally blocks this stuff, there are exceptions, listed right there in the Act.
And the sources say they focused initially on one specific exception, subsection 4.
Yeah, the one about evidence relating to a relationship between the accused and the complainant. They argued her confiding in him about Queensland created this kind of relationship of confidence.
So the evidence related to that relationship, that was the hook they were trying to use.
They also tried another angle under subsection 4, arguing the Queensland events were part of her ongoing sexual experience relevant at or about the time of the NSW allegations.
Or, alternatively, that the move, the living arrangements, the overlapping Queensland case, that all formed a connected set of circumstances.
Trying different keys to unlock that S293 gate.
Naturally, the Crown prosecutors argued against letting any of it in.
Yeah, they said the main restriction in S293.3 clearly applied, and none of those exceptions the defense were pointing to actually fit the facts here. They argued it was irrelevant, potentially prejudicial.
So the trial judge, Judge Colefax, had to make the call. And he ruled.
The evidence was inadmissible. Shut the gate.
His reasoning, based on the sources, was that the main rule, as 2933, applied, and he just didn't see how the exceptions the defense were arguing for could apply.
He also noted, apparently, that the defense hadn't quite framed their argument properly under one of the exceptions at the start.
But what's really striking are the judge's own comments about his ruling. He didn't seem entirely comfortable with it.
No, not at all. The sources quote him saying the excluded evidence was significantly probative, meaning really relevant, really valuable to the case.
He said it would directly bear upon the objective likelihood of the offenses.
Wow. And even stronger, that excluding it would lead to an unfair distortion of the facts.
But he felt his hands were tied by the legislation.
Pretty much. He apparently said Parliament probably didn't intend this specific outcome, but the law as written didn't give him broad discretion to just let it in because it seemed fair.
That really shows the tension, doesn't it, between the specific rules and the broader sense of fairness.
Definitely. So as a kind of compromise, or what the appeal courts later called an expedient,
the judge allowed the defense to cross-examine the complainant, but only by referring to the Queensland events as physical assaults, not sexual assault.
Right. A way to get something in, but without the full context or nature of the prior trauma. This phrasing later became a big point of contention itself.
And we know counsel at trial for the applicant, the defense barrister, made these arguments, countered by the prosecutor. The specific names aren't in these sources for the trial level.
A couple of other procedural things happened at trial, too. The judge gave the jury this written guide, a jury question trail to use outside the courtroom.
And he made a comment, apparently just an observation, that looking at the 17 counts, he might have thought the verdicts would be 17 one way or 17 the other, while stressing it was entirely up to them.
Right. Points that would also come up later on appeal.
So despite the judge's own reservations about excluding that Queensland evidence, the trial went ahead under those conditions.
And the result was Cook was convicted on all 17 counts.
Which, inevitably in a case like this, led to an appeal, the next stage.
Yep, up to the NSW Court of Criminal Appeal, the NSWCCA. The judges hearing that appeal were Chief Justice Beach Jones at Common Law, Justice Adamson, and Justice Ballou.
And the legal teams shifted slightly, or at least the senior counsel leading the arguments are named now. For the appellant, Cook, it was Mr. Tim Game, SC.
A very experienced senior counsel. The sources also mentioned Mrs. Julia Roy and Miss Rose Calazada were part of his team, likely assisting.
And the Crown was represented by their team from the Office of the Director of Public Prosecutions, the ODPP.
So, on appeal, Cook's team raised three main arguments, three grounds of appeal.
Ground 1. That jury question trail document was an error. Ground 2. The judge's 17 one way or the other comment was an error.
And critically, ground 3. The big one arguing the trial judge made an error by excluding all that evidence about the Queensland history under Section 293.
The NSWCCA handed down its decision on December 15, 2022. What was the outcome?
The appeal was allowed, convictions quashed, new trial ordered.
Okay, so a win for the appellant at this stage, but why? Which ground succeeded?
Well, ground 1, the jury question trail issue, was unanimously upheld. All three judges agreed it was an error.
Why was that an error? Just handing them a document.
Because the judge gave it to them to take out of the courtroom without writing it through and explaining it fully in open court first. That step is crucial.
Why? So everyone can see they understand it.
Exactly. So the judge and the lawyers can observe the jury, see if they have questions, address any confusion right then and there. It's a key part of ensuring a fair process.
And the Crown actually conceded this point.
Yes, the Crown agreed it was a procedural error that warranted a new trial. So that ground alone was enough.
But the court still looked at the other grounds, presumably for guidance for the new trial.
Correct. On ground 2, the judge's comment about the verdicts, the majority justices Adamson and Ballou dismissed that.
They didn't think it was a direction telling the jury how to decide.
No, they saw it more as just an off-the-cuff remark, an observation, not something that would actually stop the jury from considering each of the 17 counts individually.
Okay, so ground 1 succeeded, ground 2 failed. What about the big one, ground 3, the Section 293 evidence?
Here, the majority, again, Justices Adamson and Ballou, also dismissed this ground. They essentially agreed with the original trial judge.
They thought the Queensland evidence was correctly excluded under S-293.
Yes. Justice Adamson gave detailed reasons. He found the time gap between the Queensland events and the NSW allegations was too long for the at or about the time exception.
What about the connected circumstances argument?
He didn't buy that either. Didn't see the Queensland legal proceedings or the move as being sufficiently connected in the specific way the law requires.
And the relationship exception, the one based on the disclosures to Cook.
That was key. Justice Adamson found that didn't apply either. His view was that the disclosures about the Queensland offender didn't really relate to the later relationship between the complainant and Cook in the specific sense needed by Section 293 4B.
So the majority basically backed the trial judge's handling of S-293.
But there was a dissent, a significant one.
From the Chief Justice, Beach Jones.
Yes. Chief Justice Beach Jones dissented in part on ground 3. He didn't agree with the majority's take on that relationship exception, S-293 4B.
What was his view?
He felt the trial judge hadn't properly understood the core of the defense argument there. The idea that her confiding in Cook created a specific relationship of confidence, and the evidence about those disclosures directly related to that relationship.
So he thought it might apply.
He thought not enough factual investigation had happened at the trial to determine if it applied. He felt the trial judge needed to properly consider that specific argument and that this question should be looked at again properly at the new trial.
Okay, so the CCA orders a new trial based definitely on the jury question trail error.
But leaves this big question mark hanging over the admissibility of the SIS-293 evidence, thanks to the Chief Justice's dissent on the relationship point.
Which sounds like perfect grounds for another appeal, this time going even higher.
Exactly. It paved the way for the appellant Cook, to seek permission or special leave to appeal to the High Court of Australia.
The final legal frontier in Australia, and leave was granted.
The High Court hearing then took place on May 15, 2024.
And the panel of judges.
Acting Chief Justice Gordon and Justices Edelman, Stewart, Gleeson, and Jaggett. 5 judges.
The legal teams were powerhouse lineups, as you'd expect at this level.
For the appellant, Cook, again led by Mr. Tim Game SC, with Miss Julia Roy and Miss Rose Kalozazada.
And for the respondent, the king, representing the state, led by the NSW Director of Public Prosecutions herself, Miss Sally Dowling SC.
Along with Miss Monica Millward and Miss Naomi Wooten from the ODPP, top prosecutors.
So what were the arguments put to the High Court justices, building on the CCA fight?
Pretty much, but really sharpening the focus. Mr. Game SC for the appellant hammered home those Eteros 293 exceptions again.
He argued that sexual experience under the Act isn't just about past acts, but can be an ongoing state, like being a survivor of sexual assault, making the Queensland history relevant at or about the time.
He pushed the connected set of circumstances argument again, the move, the living situation, the overlapping cases.
But especially that relationship exception, S293B, right, aligning with Chief Justice Beach-Jones's dissent.
Absolutely. He argued strongly that the disclosures did relate to a relationship of confidant, that the lower courts got this wrong, and the evidence should have been let in under that exception.
And what about that compromise description, physical assaults? Did they argue about that?
Oh, yes. Mr. Game contended that description was actively misleading. It created, he said, an unsettling air of unreality because the jury couldn't grasp the true nature of the prior trauma and the significance of the disclosures to Cook.
Which undermined their whole argument about improbability.
Exactly. And he took it a step further, arguing that if the evidence was correctly excluded by the strict letter of S293, then the trial was so fundamentally unfair without that context.
That Cook should just be acquitted, not just get a retrial.
That was the argument, a bold one. He used the trial judge's own words about unfair distortion of facts to back this up.
So how did the Crown, led by Mrs. Dowling SC, respond to all this?
They pushed back hard, as you'd expect. They defended the traditional interpretation of S293.
Saying sexual experience means past activity, not an ongoing status.
Right. And that the timing was too remote, the circumstances weren't connected in the required legal sense.
And the relationship argument?
They argued the disclosures didn't establish the necessary type of relationship under S293 4B. Maybe she just needed to tell someone, anyone, rather than it being about a specific trusting relationship with Cook.
What about the physical assaults description?
The Crown defended it, said it wasn't misleading, it was legally accurate, rape is a physical assault, and it served the purpose of S293 by avoiding graphic detail, protecting the witness.
And their overall position on S293?
That it represents a deliberate balance struck by Parliament. Balancing the accused's rights against protecting complainants, courts shouldn't try to second-guess that legislative balance.
And the remedy? Acquittal or retrial?
Retrial, definitely. They argued an acquittal wasn't warranted. The defense did get some limited ability to cross-examine about prior events, even with the restriction. A retrial, correcting the procedural flaw, was the appropriate path.
Okay, so the High Court heard all these arguments. What was the final judgment delivered on August 7th, 2024?
The appeal was allowed, but only in part.
Allowed in part. What does that mean specifically?
They agreed the NSWCCA was right to order a new trial because of the jury question trail error, ground 1. That part stood.
But they set aside the part of the CCA order that had dismissed the S293 ground 3.
Exactly. So the appeal succeeded on ground 1 and in part on ground 3, specifically relating to that relationship exception.
So what did the High Court say about Section 293B? Did they agree with the appellant?
They found that the trial judge and the majority in the NSWCCA had made an error in how they approached that relationship exception.
An error in their legal reasoning.
Yes. They didn't definitively say the evidence must now be admitted, but they said the question of whether those disclosures created a relevant relationship and whether the evidence related to it hadn't been properly considered.
So that question needs to be properly decided at the retrial.
Precisely. And importantly, the judge at the retrial must also perform that balancing act required by the law itself, weighing the probative value of the evidence against the potential distress or harm to the complainant if it's admitted.
So they sent it back for the trial judge to make that call, but with clearer instructions on how to approach the relationship exception.
That's the essence of it. Though it's worth noting, Justice Jaggett dissented on this point.
What was her view?
She felt the evidence already heard at the first trial was actually inconsistent with the kind of trust relationship the defense was claiming existed with Cook.
Interesting. And what about the other points argued? The physical assaults description, the acquittal argument,
The High Court rejected both of those. They didn't think physical assaults misled the jury.
and they definitely rejected the idea that an acquittal was necessary. They confirmed a retrial was the correct outcome.
So the bottom line, new trial confirmed, but with the door firmly reopened for the defense to argue and the judge to properly consider, admitting the Queensland history under the S-293 relationship exception, including the balancing test.
Okay, so let's try and synthesize all of this. This whole journey from the trauma through all the courts, the specific legal fights. What are the big takeaways here?
Well, it's just such a vivid illustration of how deeply past events and these really intricate, sometimes quite technical legal rules intersect, especially in these sensitive cases.
And it puts a real spotlight on Section 293, doesn't it? This
Yeah.
ongoing challenge for courts.
Yeah, interpreting and applying laws like this. They have a vital purpose protecting complainants, but they can raise real questions about the accused's ability to present their full story, their full defense as they see it.
The High Court's ruling on that relationship exception, S-293-4B, seems pretty significant then.
It provides clearer guidance. It emphasizes the need for a really careful look at whether evidence of disclosures does relate to a relationship, and then that crucial step, balancing its value against the potential harm. It's not automatic either way.
And just the whole procedural story itself, it really shows how our system works, doesn't it?
Absolutely. How a case gets picked apart, refined, challenged level by level, based on specific points of law like a jury document or the meaning of one subsection of an act. It's justice unfolding step by step.
And it always comes back to that core tension, that balancing act.
Protecting witnesses, encouraging reporting, ensuring a fair trial. It's the tightrope the legal system walks in these cases.
It really makes you think about how much hangs on the precise words in legislation and how different judges can read those same words differently. It has huge impacts on real lives.
For sure. And now, as this specific case goes back for that new trial, the focus sharpens again on that S-2934B evidence.
How will the judge at the retrial apply the High Court's guidance? Will the Queensland history finally come in, and what difference will that make?
That's the immediate question for this case. But the provocative thought, maybe, is broader. How does this High Court decision ripple outwards? Does it subtly shift how laws like S-293 are interpreted and applied everywhere else?
Does it recalibrate that balance we keep talking about, or just clarify the rules of the existing game, something for us all to watch?